Partners GP Ltd LLR.
Yes, Lord Wilson.
My Lords, my Lady, I appear for the appellants in this case, together with Professor Virgo KC. I think I can skip the honorary, and Mr. Pringle to my immediate right. I'm learned friend Mr. Crowe, King's Counsel, appears for the respondents, together with Mr. Weisselberg KC and Mr. Cleaver. The court has been informed that each of the team on our side will address the court, although, of course, we will strive to avoid any overlap or repetition. In terms, therefore, of structure and personnel on our side, so the court knows where we're coming from, so to speak, I'm planning to set out our case as a whole, but I will deal only at a high level with matters that are going to be covered in more detail by either Professor Virgo or Mr. Pringle. Professor Virgo will then follow and address the court in more detail on, first, the balance of the academic opinion on the subject of the appeal, which obviously includes his own writings on the point, and also the position in the case law of foreign jurisdictions, insofar as I've not referred to it. Learned from Mr. Pringle, who's been involved in this case from the outset and the Phase 1 trial, is ready to address the court so far as necessary on how our proposed test would apply on the facts of this case. Also, insofar as either necessary or helpful to the court after what I'm about to say, and possibly in light of what my learned friend says in his oral submissions, he will pick up any further detail required as to what Mrs. Justice Cockrell actually found in this case. So, my Lords, that brings me, my Lords, my Lady, that brings me to the first point, which is perhaps a little remarkable, given the court we are in, which is what the court actually found at first instance. You'll see that the parties, remarkably, are in some disagreement, it would seem, as to what was, and perhaps more importantly, what was not found. Now, I want to deal with this point first, but very briefly and at a high level. I want to deal with it first because it may colour the prism through which the court sees the issues in this appeal. I also, however, do want to deal with it briefly and at a high level, because insofar as a point requires further detail, and we will be submitting that it doesn't, that detail will be picked up by Mr. Pringle. So our position can be put simply. When we appeared in the Court of Appeal, the parties had the same argument that we have canvassed in the written cases before this court, i.e. as to what was and what was not found at first instance. And we are therefore content to adopt the way in which the nature of the breach is recorded in the judgment of the Court of Appeal. And can I take the court briefly to that? I'm happy to take it, so to speak, in the documents, but I will also give the references to the transcript. The Court of Appeal judgment is at tab 7, and I'm looking at page 246 at paragraph 15. And the court will see there that following the Phase 1 liability trial, the judge, Roman 1, found the business opportunity had belonged entirely to SCPI, and then importantly, 2, did not find that the individual defendants, my clients, had diverted the opportunity away from SCPI, but found that they had nonetheless breached their fiduciary duties by disloyally carrying out preparatory steps while working for SCPI and the claimants, and then resigning with the intention of undertaking the recovery services themselves. And that's picked up by the Court of Appeal later in the judgment at paragraph 125, which the court will find on page 274. I'm going to use, obviously, the bundle references. In the bottom, I've got it in the bottom right-hand corner. It is clear there was no finding of dishonesty on the part of the defendants, my clients. Moreover, as I was keen to emphasise, the defendants would have been free to exploit the business opportunity for their own benefit once they had resigned, had they done nothing which constituted a breach of duty while still employees, directors, agents. Now, the key points which we take from those passages, and I will take this fairly briefly given that, and which we say are sufficient for our purposes, are that this was a breach which was not found to involve, first of all, dishonesty. We acted honestly, although we did obviously act in breach of fiduciary duty. Can I just pause there to make the obvious point? It is no part of my appeal, obviously, to go behind any findings of breach of fiduciary duty or anything else. Second, the breach was not found to involve diversion of a business opportunity. We did not divert, although, of course, much later we did end up with the contract. Third, the breach did not involve itself the receipt of profit. The money was earned much, much later. As I say, we can get into the detail of that if we need to later on, but we say those findings are clear, and I do emphasise that these are not merely, if I may say respectfully, throwaway or obiter comments by the Court of Appeal. We had the same argument before the Court of Appeal as we've had in the papers here, and this is their summary of the judge's findings, and there is no, obviously, appeal from that. But, of course, we do understand why the respondents are keen at times to talk about diversion of business opportunity because of the way we put our case. But it's very important to remember that there is no finding here of diversion of business opportunity. Again, we can come back to the detail of that later if we need to.
Well, I certainly would like your view on whether what the first instance judge said in her second judgment at paragraph 393 is an accurate reflection of her findings, because it might be suggested that your presentation of what the Court of Appeal said is not entirely consistent with what the judge has there said.
My Lord, I'm absolutely aware of that paragraph. We will come back to that paragraph, either in my submissions or certainly Mr. Pringle would be picking it up, but absolutely we're very happy to deal with that. And we
yes, because it would be odd if the judge misunderstood her own findings.
Yes, I accept that. If I may leave that point, so to speak, out there, but we will come back to it. Can I turn to the substance on the conceptual point, which is at the heart of the appeal, and the critique of the current position in the law? And let me start by making some comments on the current state of the law in the area covered by the appeal. Now, we submit it's important to make 3 points at the outset. First, we recognise that the current law is clear, at least in exposition, by which I mean that what the current test says is clear. We say, with respect, that it is not clear what the current test actually means, and we submit that it is not justified as a matter of policy. Specifically, we dispute that it has the desired deterrent effect for which my learned friend contends, and which the court will have seen in many of the cases in the academic literature, and we'll deal with the issue of deterrent in some detail later in my submissions. But we do accept that it is clear that the current test contains no causation requirement. Indeed, we see that in the Murad case, for example, where Lady Justice Arden, as she then was at paragraph 67, I'll just give the court at this moment the references, because we'll be coming to Murad later. That's in the authorities bundle, which is generally tab 8. It's at tab 23, page 1936. And then her later discussion in paragraphs 82 to 83, which we'll come to, that's at page 1941 of a higher court potentially revisiting the rule. I'll return to all of that, but we accept that the current test deliberately does not involve causation. So we are not saying that this point has in some way been overlooked. We're saying the point has been considered, that the answer given to date is wrong, and that this court, as only this court can, should substitute a different answer. And we do submit, with respect, that a large part of the case law, therefore, relied on by my learned friend, which is adduced to show that the current test for an account of profits for breach of fiduciary duty does not involve causation, is unnecessary to go to in any great detail. I will take the court, obviously, to the main cases, but we accept that that's what the current test is. We also agree that the current exclusion of a causation test in this area of the law, although not as we will see in other related areas of the law, is a deliberate decision and not an oversight. That's the first point. The second point, which is related to that, is that therefore we accept that what we are contending for would represent a significant change to the law. And it would have the result that a number of cases, including some fairly well-known cases, as set out in detail in our written case at section F, tab 5, page 171, those cases would have been decided differently. And I should say perhaps a further word about that. There is a category of case in the Supreme Court where counsel submits that the courts below have misunderstood the law. There's also a category of case in this court where counsel submits that the law has taken a wrong turn because one case has failed to take into account another decision. Now, although, as we will see, there are instances in this appeal where some previous decisions were not cited to courts in later cases, this appeal doesn't really fit into either of those two categories. In this appeal, we submit that the law as applied to date is settled, although not perhaps on very firm foundations, as I'll explain, but the law needs to be changed. And the court will appreciate that in this appeal, it is looking at this point in detail for the first time in about 60 years. Now, the respondents suggest that the court should beware of what they call judicial legislation. And we accept that this court and its predecessor have always been careful to distinguish between those areas of the law where the development should be undertaken by the courts and those areas where it should be left to some other body, whether Parliament or some other place. But this issue, we submit, the nature and scope of the remedy for an account of profits for breach of fiduciary duty, is an area that's always been regulated by precedent and not by statute. We submit it is in need of fresh consideration, and that's why we are here this morning. It may also be fair to note that none of the judges who've invited or certainly contemplated reconsideration of this area of the law have anticipated that it will be done by anybody other than this court. The third preliminary point is that our case is about remedies, and specifically an account of profits for breach of fiduciary duty. We are not inviting the court to make any changes to the law as concerns when a fiduciary duty is held to exist, i.e. the duty question, if I can call it that, or what constitutes liability for breach of fiduciary duty, the breach question. We also accept that liability is strict and necessarily so, and we don't seek to change that either. We are only concerned with the remedy of an account of profits, which we say, in its current formulation, is too harsh and too inflexible and leads to unjust outcomes. Now, the current test, we've dealt with that in some detail in our written case at section B, starting at page 140. I'm obviously not going to repeat what we've said in writing. But I do want, if I may, to reiterate the key points, and I'll pick up as I go some points that have been made by my learned friend in response, and then I'll address head-on the positive points which my learned friend makes in his written case. Now,
Can you just give me that page number again? I think it's 104. But
no, 140, my lord.
140. Thank you.
I'm sorry if I spoke. The current test is perhaps most clearly and simply, and I don't say this in a sycophantic way, it really is the best exposition, set out in grey, which is, I'm conscious, the decision in which my Lord Richards and my Lady Rose sat. That's at tab 13 of the authorities bundle, at page 1617. I don't know whether the court has them in.
Tab numbers may be helpful if there's anybody using hard copies, but we on the bench don't need tab numbers. All we need is the electronic page.
It's a page number. I'm grateful, my lord. So it's at 1617.
So I think Mr. Crow's got paper copies.
Yes.
We may need tab numbers nonetheless.
Well, I certainly want my learned friend to be able to follow what I'm saying, so I'll try and dip into them as and when necessary. So this is the decision in Gray, and the court will, I'm sure, have seen this, but the current test is set out in a section beginning on 1652, where there's a little heading C, what are the profits for which a defaulting fiduciary is liable to account? And of course, the whole of that section repays rereading. And if I can take it relatively quickly, the court will see that at 123, there was common ground that there needs to be, quote, some causal link between the asset obtained and the breach of fiduciary duty, in a reference to the judgment below. That's then cited, and at 124, the court, I think this is a judgment of the court, if I remember. Yes, it is. The court at 124 says that both sides were content to accept that passage as an adequate statement of the relevant principles, but although we heard no argument on the point, we must record our view it's not appropriate to use the language of causation in this context. And there's a reference to the ultra-fame case of Mr. Justice Lewison, and at 125, we'd sound a note of caution in relation to the unjust enrichment point. And then at 126, perhaps rather than read it out, could I respectfully invite the court just to refresh their memory of 126 and also 128.
But 126 and
128.
thank you.
Let's deal with it later. Now, the reason why I take it from there is that the points are, if I may say, clearly set out there, and that test is also the one applied in Murad, Keystone, and also the present case. Now, as we say in our written argument, the current test has a positive and also a negative aspect, and I'll deal with each in turn, if I may. The positive aspect, i.e. the test that the court is currently required to apply, is that the court has to consider, in order to determine the scope of the account of profits, whether a given profit is within the scope of the fiduciary's duty, and or whether there is a reasonable relationship between the profit and the breach. Both terms have been used in the cases. We say that neither of these tests is fit for purpose, and we make that submission both in general, but in any event, especially in a case such as the present, where the profit does not form any part of the actual breach, i.e. what I will refer to as a pure no-conflict case. Now, the respondents do not seem to contemplate or countenance the idea that there can be pure no-conflict breaches which do not involve, as part of the breach, the receipt of profit, but for which breach, nonetheless, the beneficiary can obtain a remedy of an account of profits. But there can be such cases, and we submit this case is one of them. This is not a case, for example, where the trustee or fiduciary has taken or diverted to himself trust assets whilst in office, or where the trustee or fiduciary has received funds whilst in office that he's obliged to hand over to the beneficiary, for example, by way of a secret profit, as in the FHR Ventures case on which my Lord Hodge sat. In those cases, if we were to ask the fiduciary to account for the profit, and I'm using the word account there, whether as a primary duty whilst in office or a remedy if that duty was said to have been breached. And I'll return to that, those different uses of account later. If we were to ask the fiduciary to account for the profit, the fiduciary would immediately know what profit we're talking about. That category of case, we submit, accounts for the vast majority of the leading decisions in English law, for example, Murad and also Gray. In Murad, for example, Mr. Al-Sarraj obtained his share in the hotel via his investment of the secret commission which he had received in breach of duty. Gray was effectively a diversion case. Mr. Gray, while still part of the joint venture, caused the ultrasound technology business to be obtained by vehicles in which only he was interested, rather than securing it for the joint venture vehicle which he was supposed to be promoting. But in the present case, there was a breach of fiduciary carried out whilst in office, but that was something short of an appropriation or diversion of property belonging to the beneficiary. There was no misappropriation of trust property. But in this type of case, money has been earned by the fiduciary subsequent to his resignation from office, and therefore the cessation of his fiduciary duties, because they ceased on resignation. And the question is whether any particular part of the profit derives from the breach carried out whilst in office, such that he has to account for it. And in that context, if we ask the question whether the fiduciary has to account for the profits, we submit that immediately begs the question, which profits? To which the answer must be, we submit, only those profits which result from the breach, i.e. we would say only those profits caused by the breach. Now,
so are you saying that this doesn't belong within the category of secret or unauthorised profit?
Essentially, it belongs in the category of, we're not suggesting that they can't get an account of profits, but it doesn't follow that all the profits we made are profits for which we have to account to the beneficiary.
Lord Wilkinson, I thought that you were here exploring the current test, the current law, but I think what you've just submitted is what you say the law should be.
Yes, sorry, yes.
So, I see. Right.
Maybe I misunderstood my Lord Burroughs' question.
So we've moved away, you've left an investigation of what the state of the law is without, I may say, any reference to the test as set out in Regal, Hastings and Gulliver. Because the problem with Gray, if I may put it this way, as one of the authors, is that we don't really explore what it is that brings into being the duty to account. It's really to Regal Hastings in particular and Phipps and Baldwin that one must turn for an exposition of what that is.
Absolutely, and I'm going to go to Regal Hastings, and when I deal with Murad, and also when I deal with the Singapore case of UVJ, my Lord is, with respect, absolutely right, because the pivot point, if I can put it this way, is does the current test, when you exclude causation in the sense that I'm using causation, i.e., whether the fiduciary would have made the profit even if the fiduciary had not been in breach of duty, is that something which arises from Regal Hastings? And we'll see that when we come, I hope, to UVJ in the Singapore Court of Appeal, and we'll also see it when I come to Murad, because my Lord is absolutely right. We will look at Regal Hastings, and in particular what we have to do is to look at how Regal Hastings has been used as the, I was going to use the word springboard. I know that's got other connotations, but my Lord knows what I mean. The basis, the genesis
yes.
of the test. So we will absolutely come to that.
But does the causation test that you say, you said there you have to ask whether the fiduciary would have made a profit even if he'd not breached the duty, but is it also part of your proposed causation test that the principal would have been able to earn the profit if there had been no breach of duty?
No, I'm focusing only on the first of those questions.
Yes, you're not challenging the latter, as I understand it.
I'm not.
It is simply applying a but-for test,
My Lord Richard.
to the fiduciary's receipt of the money.
My Lord, yes. I'm sorry to cut across, my Lord.
It's quite clear in your case, I think. Yeah.
That's absolutely. That's all I'm doing, and therefore, the point at issue actually is therefore a pretty narrow one. I mean, it's obviously a very important one, but it is a pretty narrow one because it's only that but-for causation point which I'm seeking to argue. I'm not reopening questions about whether it makes a difference if the beneficiary could have made the money themselves, whether the beneficiary has suffered a loss or anything else. Indeed, it's irrelevant whether the beneficiary has suffered a loss or not, because we're dealing here with an account of profits. So I'm not seeking to argue quite a lot of the points which the courts have said in their judgments are not open to argue and are irrelevant to the question of an account of profits. The only focus of my argument is the but-for causation test.
It's impossible to avoid language of causation in a broad sense, because obviously whatever you say, it's got to be derived from or as a result of. I mean, there is a causal test.
Yes.
But I think what is meant when saying that causation doesn't apply is not the same test as would apply, say, in the question of loss caused by a breach of contract or something like that.
Yes.
It's a different test. And obviously but-for causation is only one test, and even in the loss cases, there are plenty of examples where it doesn't operate.
Yes. Clearly, the test cannot merely be, so to speak, subsequent in time.
No.
Because that isn't a test at all.
No. There's got to be some link, and in a broad sense, that has a question of causation.
Precisely. Yeah. And what I'm submitting, essentially, is that given that there has to be a test of causation, have we used that word, the appropriate test in this area is but-for causation. Merely the fact that B follows A doesn't help you. I mean, that's a language of novels. That isn't the language of law. So there has to be some link, and we say that there has to be a causal link, and the most appropriate causal link in this area is but-for causation. And I'll develop that point a little later.
So, but for the breach of duty, the fiduciary would not have made a profit. That's how you put it.
And do you apply that across the board in the sense of applying where the profit has been made while the fiduciary was still in office, or only to cases where the profit is made after the fiduciary has left office?
Well, as we said in our written case, my Lord, one could split it in the way the second half of my Lord's question indicates, but it would probably be more conceptually sensible and conceptually pure to apply it generally, albeit that in the first type of case, it's going to be asked and answered almost immediately. It's going to be obvious what the profits are and whether the fiduciary would have made the profits absent any breach of duty.
Why is that more obvious in the first rather than the second case?
Well, in a case where the fiduciary has appropriated to himself assets, then in the vast majority of cases, if not all cases, he wouldn't have those assets if he hadn't acted in breach of duty. But
well, you might run the hypothetical, had they actually sought authorisation, there would have been no difficulty, so you could still run it there.
I absolutely accept that, and that's why my primary answer to my Lord's question is that you ought to apply the same test, albeit that it would be easier to satisfy, especially if the burden is on the fiduciary, which we're submitting it should be.
But I think my problem was back in the question I asked.
Yes.
It seemed to me you were trying to differentiate between a situation where the profits are made subsequent to remitting from office and prior to that point. And that was my slight, I wasn't quite sure I understood where that was coming from, and is that central to your case?
Yeah, my lord, I think I'm about to come to that point. Should I make the points I'm about to make? And I hope they will provide an answer to my lord's question.
Thank you.
If they don't, I'm sure that my lord will come back.
Thank you.
We submit that there are 7 points, perhaps, which I can take shortly in this area, which I hope will set out the way we scope it out. First of all, there is no fiduciary duty not to resign. A fiduciary can resign without that resignation involving any breach of duty. Indeed, the fiduciary can resign even if she knows that the consequences will be catastrophic for the beneficiary, or if the fiduciary is a director for the company. Second point, nor is the fiduciary prevented after resigning, and in the absence of any other breach, from competing for what the fiduciary knows is a business opportunity that the company was pursuing before the fiduciary left, and about which the fiduciary learned by virtue of her office.
So just to take the fiduciary is not prevented from, just can you say more?
From resigning, and in the absence of any other breach, from competing for what the fiduciary knows is a business opportunity that the company was pursuing before the fiduciary left, and about which the fiduciary learned by virtue of her office. Third point.
I mean, that's.
Have you got an authority?
You're quite sure about that? I mean, what's the authority for that? Supposing that it was confidential information, that it was confidential, that wasn't generally known that the opportunity was available. Why?
I've said in the absence of any other breach.
Well, not breach.
Would that be
just supposing it's not public knowledge that there's some opportunity available. How would this second proposition play out?
Because if you're using confidential information, you'd be in breach of duty to the company by using that confidential information.
But so it's the fact it's not public knowledge that makes the big difference there, is it?
Either it's not public knowledge, or I'm going to come a little later to the diversion of business.
This is an opportunity that comes to that fiduciary because they were a fiduciary. So then they resign to take advantage of that knowledge. So you say the critical point there is that it was not public knowledge that that opportunity existed.
Yes.
Is that an abuse of confidential information? Is that properly categorised as that?
You're certainly misusing information which, if the opportunity is properly categorised as company property, an opportunity which belongs to the company.
But I mean, on this basis, Regal, Hastings and Gulliver was clearly correctly decided.
It's not going to...
Or indeed Phipps and Boardman. Because in Phipps and Boardman, the defendants came by a lot of confidential information about the company while saying they were acting for the trustees.
Yes, and they were liable in Phipps and Boardman because they didn't get the consent of the beneficiary.
Well, that's ex hypothesi in all your examples.
Yes. So in Phipps and Boardman...
Why would they need the consent if it wasn't a breach?
Because in Phipps and Boardman, they had an obligation to pursue the opportunity for the benefit of the beneficiaries.
But then, if they resign, you say that obligation disappears.
They don't owe the obligation after they resign.
Well, what's the answer to my question then? You say it does disappear. If you resign, then you can set up your own company and go after that opportunity.
Provided you, this isn't central to my appeal, but provided you're not misusing information that you obtained while in office, or you didn't do anything while in office to set up or tee up the competition. The reason why we were found liable in this case, for example, is because we teed up while we were in office the position so that once we resigned, we were in a better position to compete.
Yes, I know it's your case. That's your case. What we're exploring is whether you're right to say that.
Yes.
It's your second proposition. I mean, I'd be very interested if there's any case law that articulates that proposition. I'm not aware of any.
No. And I mean, I think there may be a key point here, because you're stressing that what your clients did wrong was to start the process going while they were still involved.
Yes.
But I think the key point is, a key point at any rate, is even if they hadn't done that, they knew of the opportunity to deal for this family as a result of their engagement. It wasn't, well, I'm not aware it was public knowledge. And at the moment, I'm not quite sure where I see the difference between that and Phipps and Boardman.
Well, I'm going later to deal with.
Which you say was wrongly decided, I think.
Yes, I'm going later to deal with the business opportunity cases and IDC and Cooley, and perhaps I can.
Well, I know, but I mean, you see, Phipps and Boardman isn't a business opportunity case.
No.
Because it wasn't an opportunity available to the trust. I mean, it's clear from the judgments they couldn't invest further in the company in question. So what Mr. Boardman and Mr. Phipps did was they purported to act on behalf of the trustees of the trust. They weren't themselves trustees, but they represented that they were acting for the trustees when in fact they weren't, but not in any dishonest way. And in that capacity, they got a whole lot of information about the company. That is what they then used to buy the shares in the company. Now, what's the difference here? And remember also, by the time they bought the shares, they were no longer saying they were acting for the company.
Yes.
It was equivalent of having resigned.
Yes.
So what's the difference?
Yeah.
I'm having difficulty in understanding.
Yeah. We submit the difference is that the question is whether the opportunity which you're pursuing is properly seen as something belonging to the beneficiary.
Well, belonging to? I mean, this gets into this very dangerous territory of thinking of information as property, which clearly it isn't.
Yeah. Well, yes, that's a bit of a chestnut question, and indeed...
Not really a chestnut question. I don't think anyone is now going to say
Exactly.
that information of this sort is property.
And the dissenting judgment in Boardman and Phipps actually makes...
Yes. I don't think it's the ratio of the majority.
No, it isn't.
Information.
It isn't.
But in your second proposition then, you say it's a business opportunity that the company was pursuing before the fiduciary left, but now you seem to be distinguishing between, on the one hand, a business opportunity that the company was pursuing, and on the other hand, a business opportunity which belongs to the company in the sense that it would be diverted from the company if the fiduciary, before resigning, took it for himself. But it is when, I mean, one could see a director's working for a, I don't know, window installing company, and everybody sees published in the paper a big building with lots of windows is decided to replace all its windows. The company may decide, let's go for that, but you say a director who reads about it in the paper could resign from that company, set up his own window replacing company and bid for that. That would be different from something, in that circumstance, the opportunity to replace all those windows doesn't belong to any particular company, even though he happened to be a director of the company when he read about it in the newspaper. Is that the situation that you're envisaging?
Yes, I mean, the starting point is that there's nothing wrong. There's no fiduciary duty. There's no fiduciary duty not to resign. There's no breach in actually resigning.
Except where it's to facilitate a breach of trust by the other trustees or fiduciaries.
Right. So the question is...
There is a circumstance, but not ours, I suppose.
Exactly. So the question is whether there is something which, together with the fact of the resignation, amounts to a breach of duty. Here, the reason we were liable here is that we took preparatory steps which, followed by a resignation, amounted to a breach of duty. My submission is, and I don't want to tread on Mr. Pringle's toes, but my submission is and will be, and our submission will be, that if we'd done it the other way round, we wouldn't have been in breach of fiduciary duty.
Well, I think that's what we're all
Exactly.
querying.
Well, that is what you're saying, but again, is this second proposition being presented to us as existing law or as something the law should hold? If it is the former, can you give me any authority to support it?
Yes. It is, we are submitting that this is where the law is, but can I come back to that point? Because I know I'm going to come back to this point later in my submissions. And if the court will forgive me, can I come back to that? Because I want to make sure we get this right.
When you do, Lord Wilson, I hope you'll help me out of an area of inquiry which focuses on the nature of the business opportunity. It's one thing to say you're acting as a director for a company which is competing to, I don't know, build a ship or provide something to the counterparty. But this is a very different kind of business opportunity because it appears to be able to conduct a recovery business in relation to the distributed and largely invisible assets of a family. And the ability to do that recovery well depends upon the most intimate knowledge already acquired, as I understand the facts, about the family and the deceased's disposal of his assets, all of which was acquired while acting as a fiduciary. Whether it's confidential information doesn't seem necessary to answer the point. It's whether it's complicated knowledge which is key to your being able to provide or to achieve the business opportunity, to provide the relevant service, and where you got that from and what hat you were wearing when you got it.
Yes, yeah, because the key to the problem is that you put yourself in a situation where your interests conflict with your duty to the company, for example, of which you're a director.
Yes.
The key to the issue isn't property rights in information. It's the duty of fiduciary not to put himself in a situation where his private interests conflict with his fiduciary duty.
Yes, or if I may put it another way, as my Lord Briggs put it extrajudicially, the key to it, perhaps I can just put it another way, is the fundamental duty of loyalty. I mean, that's really what lies at the heart of all of these fiduciary duties.
Yes,
but it doesn't follow that you can just resign and say, fine, go on, no problem. If you're sitting on a great arsenal of information which will help you provide the business opportunity in the form of a service to a third party, which arsenal you only got while you were a fiduciary.
That's precisely why I'm asking for some authority to support this proposition.
I appreciate. Well, can I
just, a practical matter, would you be able to let us have these 7 propositions in some written form in case we note them down wrongly, which I am absolutely bound to do?
I agree that I will, but I'm agreeing to the first part, not
Indeed.
the second.
No, all right. But simply the proposition,
yes.
No more than that.
No, absolutely. Yeah.
Thank you.
Should I continue to go through them, and then I appreciate there's some questions outstanding which we will obviously pick up. Nor is it objectionable, third one, nor is it objectionable without more, for the fiduciary to resign with the intention to do that, i.e. there's no liability for thought crime per se. Fourth, a fiduciary ceases to owe fiduciary duties when she resigns from office. Fifth, in order to be liable, therefore, one has to ask whether the fiduciary did anything disloyal whilst in office so as to tip the opportunity when she left, such that the resignation with intent to compete is rendered a bad faith resignation, using the language of the judge in this case, and therefore a breach of duty. And in that context, sixth, the judge held the disloyal acts whilst in office need not be such as to amount to a freestanding breach of duty in and of themselves. It's the combination of those acts with the resignation that amount to a breach of duty and what she called a bad faith resignation. Seventh really follows that our submission is that is what these appellants were found to have done. That will lead me treading on Mr. Pringle's toes.
So there's no finding, is this right? Does this follow from 6 that there was any breach of duty while in office?
Well, The finding was obviously a finding of breach of fiduciary duty.
Yeah.
Well, what exactly was the breach of fiduciary duty?
The breach of fiduciary duty has to be, so to speak, whilst in office, because my
Well, no,
suspicion
what was the breach
Yes.
of fiduciary duty found in this case?
that we took steps whilst we were in office. We talked to the family, we disparaged Mr. Jaffe, which enabled us to be in a better position
Yes.
immediately to...
Those were surely all breaches of duty while in office.
Yes.
Well, I'm sorry, because I thought your proposition 6 was that disloyal acts while in office need not be a breach of duty. I noted down.
She does
but
say,
in this case, they were a breach of
yes,
duty.
the judge says that it's not necessary to show, that the steps taken were themselves breaches of duty.
But that's an irrelevant point so far as this case is concerned.
So well, this case, but I'm obviously trying to present the position on a more general basis.
Yes.
Now,
And it occurs to me that the conflict of interest is a reason why the company doesn't have to have been pursuing the opportunity or even know of the opportunity. If the information comes to the attention of a director, for example, and it's material to the company's interests, then he has a duty to disclose it.
yes. Yes. I mean, and of course, I don't dissent from that. Of course, in this case, this isn't a non-disclosure case. I mean, this isn't a case where we were doing anything. The opportunity was not known to the beneficiary. The opportunity was well known to the beneficiary. The steps we took to put ourselves in a position better to compete, those are the breaches of duty found in this case. It's not a non-disclosure case.
I think the pushback you're getting is that although those are important features of this case, they may not actually be necessary features for your clients to have been held accountable. That it's enough that they had the information, came to them in their capacity as fiduciaries.
Yes, and that may mean that we'll need to look a little later at CMS Dolphin and Foster Bryant, where there is a discussion in the authorities as to the information point, if I can put it that way. And certainly in Foster Bryant, Lord Justice Ricks takes issue with the way Mr. Justice Lawrence Collins, as he then was, put it in CMS Dolphin. Now, the primary way, I'm still on the way the test is put at the moment, the primary way the test is put is whether the profit earned by the fiduciary was, quotes, within the scope of the fiduciary's duty. That's the way it's generally put in the authorities. And the authorities, as we say in our written case at paragraph 16, page 144, refer to the issue as being whether the conduct of the fiduciary was within the scope of his duty. But here we submit that the objectionable conduct before the resignation did not itself involve profit. The objectionable conduct was the steps we took before we resigned, and I accept what I'm about to say is going to take me back into the discussion we've just had, which we could have taken after we'd resigned without that being a breach of duty, these particular steps. Now, so we say that it would be beneficial and desirable to have a single test which applies across the board to all breaches of fiduciary duty, to pick up the point which I think my Lord Briggs asked me earlier. Now, other times in the case law, the question is put in terms of reasonable relationship. And again, there is no definition there of what is meant by reasonable. There's no way of telling whether the test is made in a given case. And if reasonable relationship doesn't involve causation, as my Lord Legate pointed out, then really what we're left with is either unfettered judicial discretion or merely post hoc. And post hoc is not propter hoc, if I can pick up the old tag. And the same is true of all the other variations, as we've set out in our written case of the test, whether that's sufficient connection, reasonable connection, factual matrix, Whatever nexus it is, those phrases, all they really tell you is that some connections are insufficient, but they don't identify what connection is sufficient. And we say that those tests really are more redolent of a remoteness test, i.e. to identify the outer edge of the relevant pool of profits. And they might be sufficient for that purpose, but you do have to populate the pool of profits in the first place, and we say that requires a causation test. That's the positive part of the current test. The negative aspect of the current test is that there is no causation element. And that is obviously by design, it's not an oversight. It's most clearly set out in terms of recent cases in Murad, which I'll take the court to in a moment. But similar statements appear in Keystone and Parr per Lord Justice Lewison at page 1865, and in the Court of Appeal in the present case at paragraphs 35 to 36, which is page 252. And they... 252.
Thank you.
And they rely on the principle, for this principle, on what was said by the House of Lords in Regal, Hastings and Gulliver. So if we pick it up in terms of Murad, which is at page 1936, if we pick it up at paragraph 67 in the report, which is 1936, the court will see that Lady Justice Arden first notes that the fact that the fiduciary can show that the beneficiary would not have made a loss is irrelevant so far as an account of profits is concerned, and we respectfully agree, to pick up the point put to me by my Lady Rose. But she then goes on to say, to pick up my Lord Richard's point, in the second half of 67, having said that whether the other party wouldn't have made a loss is irrelevant, likewise, it follows in my judgment from Regal that it's no defence for a fiduciary to say he would have made the profit even if there'd been no breach of fiduciary duty. And in our respectful submission, that line of argument involves a non sequitur. The passage from Regal that is cited by the court in Murad, and if we go back to paragraph 60 at 1934, the court will see the passage from Regal, which is cited, if I may say, in all of the cases. It's a classic citation from Regal. And that passage is concerned with whether the beneficiary could have earned himself the profit in question, i.e. the profit which the fiduciary has made and which is the target of the account of profits, or whether the beneficiary has suffered a loss. We accept that the court is not entitled to look at either of those questions because an account of profit is concerned obviously with the fiduciary's profit and not the profit which the beneficiary might or might not have made, or with the beneficiary's loss. And so asking whether the beneficiary could himself have made the profit in question or has suffered a loss is nil ad rem. It's beside the point. But
the point you'll no doubt come to is what I think underpins Lord Russell's dictum here is that what we're talking about isn't a remedy at all. It's not a remedy for a breach of fiduciary duty. It's rather the duty of a fiduciary to account for any profit arising from his position.
Yes. The nature of what we mean by an account and whether an account is a process or a remedy, and the distinction between an account in the sense of any beneficiary at any time can ask for an account from their trustee, i.e. what's in my trust, and the remedy, as it's often seen, of an account of profits for a breach of fiduciary duty. That's something which I will come to in some detail later on.
It may be said that you're missing out an undistributed middle from saying it's just a process or a remedy, because it may be a duty. In other words, it's not just a process that the beneficiary can come on and say, well, give me some accounts. It's a duty inherent in the fiduciary office to account for profits made by reason of, or in the course of, or which have the relevant connection with the office.
Yes.
And the remedy is simply forcing the trustee to perform his duty, namely what? A duty to account.
Yes, and I absolutely will come to that. And as my Lord knows, because my Lord has written about it, when we come to the Singapore case of UVJ, there's some nice, if I say respectfully, some nice learning there on precisely that point. And
but I'm just troubled by the notion that it's a one or the other.
I was
missing out the duty to account.
I was just summarising the point, and of course I accept there's a duty to account, absolutely. And indeed, when the right of a beneficiary to say to the trustee, what's in my trust, please account to it, is the flip side of the trustee's duty to account to the beneficiary.
Well, not quite, actually. I mean, the trustee has a duty to account for any profits he's made by virtue of being a trustee, let's put it. I'm not meaning to draft there, as it were. That's one thing. If proceedings are brought by the beneficiaries and it's obvious what the profit is, then the remedy is straightforward. Yes. The court orders the trustee to pay £8. If, however, it's complicated, the court orders the taking of an account.
Yes.
So it's sort of, so in a sense, there are three senses in which the word is used. There is separately, though, the beneficiary who says, what's in my trust? In which case you then take an account. And that there may or may not be a profit involved in that. But in our context, I think it's those three senses in which account is used.
My Lord, I wouldn't dissent from that. And indeed, if I may say, I mean, classically, if we go back, and I hope I get this right, as somebody in the temple rather than Lincoln's Inn, classically in pleadings, there was the taking of account and then payment on the taking of account. Yes. And I think that goes to the point my Lord was just making.
Well, I actually was making another point, which was that if on the facts it's obvious that the profit is £X, then the court simply orders the trustee to pay £X. Yes. We don't bother with taking an account.
Absolutely. Yes.
But is it significant for your case that you? I mean, I think what we're getting presented here is, at least in many cases, you can see the account as the duty without any prior breach. It's not a remedy for the breach. It's actually a primary liability to account.
Yes.
That's one analysis. The other analysis, but I'm really asking you, is it the case that you can always use these two ways of looking at it? The other analysis is, well, you've got a breach, and then as the remedy for the breach, you account.
Yes.
I mean, is it significant for you that it's got to be the second of those rather than the first?
It's significant in the sense that when you present it in the second way, you are asking more directly the question, which profits are we talking about? For which profits do you have to account?
Right.
Yeah. Because in the second context, there is a question as to the relationship, just to try and use neutral language for the moment, between the profits and the breach. Because otherwise, it's not the case that all profits subsequently earned by a fiduciary come within the scope of the account. There has to be some relationship.
Yeah.
Yes, and the Privy Council in the New Zealand Netherlands Society stated it as the obligation not to profit from a position of trust.
Yes.
Yes, so that's the point you're making.
Yes,
There has to be a relationship between the fiduciary obligation and the profit.
Yes.
And we can see in cases like Warman and Dyer, where there's, if you like, initially, everything you're making from the newly established business is within your obligation to account. But there comes a point where it's so different and where the profit-making features of it are so unconnected with your previous role that, if you like, the obligation to account ceases. At least that's what the court decided in that case.
Exactly, and of course Warman and Dyer has been, I'm going a little out of my order, but
Yes.
to pick up the point.
We're going to get there sooner or later.
We might as well touch on it now since my Lord raised it. Warman and Dyer, of course, have been seen in two distinct ways. we submit, and the Court of Appeal in this case saw it as a causation test, i.e. after 2 years have gone past, there is an insufficient relationship, to put it in those terms, between the profits that are being earned by the new venture and the breach. You can, of course, get to the same result, as some commentators have said, by saying, well, we'll give you, by way of equitable allowance, which I'll come to as well, 100% from 2 years onwards.
Well,
you get to the same event.
Not what they did, I think.
Sorry?
Not what they did.
It isn't what they did. We submit that Warman is a case where the court is essentially saying, after 2 years, the money you're making has an insufficient link, to try and use neutral language, to the breach which you've been held liable for. And therefore, the profits after 2 years do not fall within, I was going to say fall within the account. What I mean is they may fall within the account, i.e. you have to identify them, but they don't fall within the payment you have to make on the taking of the account.
Well, we'll have to look and see whether it was a connection with a breach or a connection with a former fiduciary relationship.
Well, I think that's the key. We keep coming back to my Lord Reid and my Lord Burrows made this point to you, that it's not necessary to have a prior breach. The only breach is the failure to account for a profit made in certain circumstances. And the example you're giving derived from Warman is that the circumstances are such that there's no duty to account and therefore no breach. But I mean, a lot of what you say in your case, in your written case, seems to posit that the duty to account can only arise where there's been a prior breach, and that's a proposition which I would question.
Yes, I'm certainly not saying that the duty to account can only arise from a breach, and as I thought I answered earlier, I'm accepting that there is an obligation to account in the sense of what is in my trust, the beneficiary can ask, and the fiduciary has an ongoing obligation not to profit from the fiduciary relationship in an unauthorised way. But when we come to the language of account, I mean, this gets us into, I think it's Professor Smith has written on this in some detail, the primary and secondary obligations, whether there's a primary obligation to account or we're talking about a secondary obligation. And I'm trying to avoid, if I may, getting too much into that academic debate, but I do submit it's helpful to think about these cases differently, where there are some cases where the beneficiary is coming along and saying, what's in my account, what's in my trust. Other cases where the beneficiary is saying, you seem to have money which you've obtained illicitly, illegitimately, please account for it. And third, where the beneficiary has come and said, you've acted in breach of fiduciary duty, the court has so held, and the court has ordered an account to be taken. And an account in those circumstances may include a pool of assets, not all of which, it turns out, have the requisite connection to the breach.
I think this is more of a second category of case. You, the former trustee, have assets which you shouldn't legitimately have.
Well,
because they're derived from information which you obtained while you were a fiduciary.
There's
no other breach of trust involved.
There's the breach of trust, the breach of fiduciary duty here was that we were found to be in breach for were the steps taken before we resigned.
And was that a necessary ingredient in the liability found in this case?
In my respectful submission, yes, but I appreciate that we're going round on that particular point, which I will come to, I mean, we will deal with it.
But I think it's important, isn't it, that we do articulate the extent to which your submissions rest on there being a secondary liability rather than a primary liability. Because if it's a primary liability, we've got no causation problem.
Exactly.
So it's only if you're seeing this as a secondary liability, triggered by breach, that we're into your way of looking at things.
Yes, I agree.
Yeah.
Yes.
Now, it may be that you would want to say that bar a very obvious initial case of a trustee who is actually being asked by the beneficiary account for gains that belong to me as a beneficiary, you're maybe perhaps saying that every other example can be helpfully seen as triggered by a breach.
Yes.
It may be that there's another analysis, but that is at least one way of looking at it. Is that a fair way in which you're putting it?
It is, and I'm very content to adopt that, if I may say.
Can I just put one more marker down before you move on? You said that Warman and Dyer can be looked at as a case where they applied a causation test to see what profits, in respect of what profits over what period of time the former fiduciaries were accountable. I'd be helped if at some stage when we get there, you can say whether they're applying a but-for causation test or simply looking at what actually happened, not worrying about the counterfactual, and simply saying, well, there is the sufficient nexus, if you like, between what you took away from your former employers as a fiduciary and the profits which you later made in the new business which you set up.
Yes. When we come to Warman, let's...
Thank you.
I'll pick
it's
that
just a marker. You don't have to deal with it now.
I'm grateful. Can I just come back to my point on Regal, because I'm just conscious I was asked a question on Regal, and I need, because Regal is the genesis for a lot of this. The submission we make, and of course we have to make this submission, and we do, submission we make is that the House of Lords in Regal did not deal with the question whether the court should look at whether the fiduciary would have earned the profit but for the breach. And so we submit that it doesn't follow from the dictum in Regal set out at 1934, or from anything that's said in Boardman and Phipps or Keach and Sanford, that the court should not look at whether the fiduciary would have earned the profit but for the breach. And that's a different question to whether the beneficiary would have earned the profit or whether the beneficiary had suffered a loss. And we do say that the question is whether the fiduciary would, rather than could, have earned the profit, because this isn't some form of idle speculation. It's a fact-finding exercise as to whether the fiduciary would have earned the profit in question if there had been no breach of duty. And this is the point which was considered, as I said earlier, by the Singapore Court of Appeal in UVJ, by reference to a case called Mona Computer, which in turn cited Regal directly. The Singapore decision is at 3028. From a learned friend, as he knows, it's tab 53.
I'm sorry, the page reference was?
It's 3028.
Thank you.
This is the UVJ case.
It is. And the court will see, if we pick it up at 3028, that there's a reference at the beginning of paragraph 79 to Mona Computer, and they set out what Mona Computer was about. And then over the page on 3029, still quoting from Mona Computer itself quotes from Regal Hastings, a passage which we've seen. That's the same extract from Murat. And the question whether the fiduciary's conduct has caused loss to the principal. And having quoted that, they summarise at paragraph 80, which I won't read out, what Mona Computer decided. And then from paragraph 83, there is a discussion of the relevant principles. And at 83, about halfway down that paragraph, they make the point that they don't think the decision in Mona Computer should be read as indicating that but-for causation is not necessary. We also note that while loss to the beneficiary and gain to the fiduciary are often two sides of the same coin, not necessarily true of all cases, one need not follow the other. And at paragraph 85 on page 3032, they note that they were referred to Regal and IDC in Mona Computer, these were referred to for the purposes of making the point it's immaterial whether the company would, if in order for an account of profit is made, receive a benefit it was unlikely to have gotten for itself. Then at 86, they refer to Murad, and the court will see there's a long selection from and citation from Murad in 86 for the proposition that causation is not necessary. And then at paragraph 87 on 3034, they make the point that while there are passages in Murad which conclude that causation is not relevant in ordering an account of profits, most notably at 67, which they've reproduced, we ask whether this is a position that we should adopt, insofar as Murad relied on long-standing authority in England, and such authority does not bind this court. And at 88, they refer to the policy considerations which are said to underlie the rule. And we see this picked up. Justice Alden refers to these in Murad itself. We see these discussed in quite a lot of the academic material in the bundles. There are essentially two policy reasons. The first is what you might call hypothetical investigations, i.e. working out what would have happened in the counterfactual. And the second is deterrence. And I'll come back to both of those points a little later on. 89, but they end 88 by saying deterrence should not be a password to avoid causation. And 89 is really the key paragraph. Lady Justice Arden appears to have been influenced by the irrelevance of the beneficiary's loss to an account of profits in holding it's no defence for a fiduciary to say he would have made the profit even if there had been no breach of fiduciary duty, i.e. there was no but-for causation. As we've explained above, we do not think this would be the correct approach. The reason why beneficiary's loss is irrelevant is that an account of profits as a gains-based remedy is concerned with the gain of the fiduciary. This would not explain why causation between the fiduciary's gain and his breach of duty would be irrelevant. Now, of course, it may be relevant in this context, perhaps more as a historical note than a legal submission, that, of course, Regal was not reported in the official law reports until after Boardman and Phipps. We all know that it's reported as a note after Boardman and Phipps. It seems from our researches that it was only referred to, I think, 9 times in the intervening period, not in any great detail. And although it was actually reported in the All England reports back in 1942, it certainly didn't get the attention which it subsequently received until it was cited in Boardman and Phipps. And indeed, it's fair to say in Boardman, it wasn't relied on even in Boardman for the point which the court took from it in Murad and in the other cases I've mentioned. Now, while I'm on Regal, I should note that the respondents say that this part of the test, i.e. that the court should not look at whether the fiduciary would have earned the profit but for the breach. Malone Fence admits that this actually predates Warman.
Predates?
Relies on the...
Predates Boardman.
Yeah, sorry, Regal. I'm sorry. It predates Regal, forgive me. It predates Regal, and he relies on the Brickenden case in 1934. Now, that's at 2699. Of course, that's a decision of the Privy Council. But more relevantly, it's also an equitable compensation case. It's not an account of profits case. And as the court knows, in equitable compensation, there is certainly now a causation test. And in that context, we submit the statement of Lord Thankerton at 2703, that in a case of non-disclosure, you do not ask, when considering a claim for equitable compensation, what the beneficiary would have done if disclosure had been made. We submit that's actually inconsistent with later House of Lords authority in Target Holdings and also with the Court of Appeal's decision in Swindle and Harrison, where a but-for causation test was applied.
Sorry, so you took us to page 2703.
And it's the penultimate paragraph beginning when a party.
Yeah, commits a breach of duty.
But my main submission on this case is it's an equitable compensation case, and it's fair to say, for reasons we've set out in writing, that this case, it's very difficult now to reconcile with, we would say, Target Holdings and also Swindle and Harrison. Indeed, if we pick it up, if I can show the court Swindle and Harrison, just to make that point, which is at 2316. Friend, it's tab 33. If we turn through to page 2328, or 2327 perhaps, what we see at 2327 is the citation between C and E of the passage of Lord Thankerton, which I showed the court in Brickenden. And you'll see at the bottom of the page, after J, the submission of Mr. Bannister, QC, applying Brickenden. And over the page, that is rejected between A and B. And it's also said to be inconsistent between D and E with Target. So this may be a sort of historical footnote, but we do submit that Brickenden's position in English law now is somewhat precarious. And if I can just give the court references rather than go to the academic material on this point, which is in the bundle. Dr. Van, in her article, and the reference is 3274-5, notes that Brickenden's position in England is uncertain, and although, quotes, it's not been explicitly denied, it, quotes, may be reaching the end of its useful life. And also Mitchell and McFarlane at 3466 note that the latter cases, or the later cases, preclude speculation as to what course the principal would otherwise have taken, but if the fiduciary can show that the beneficiary would not have acted any differently, he can escape liability. So we say that Brickenden isn't a case which establishes the proposition that in counter profits cases there is no causation test.
Could you just give me the Venn page reference, please?
3274-5.
3274-5, thank you.
The other case Malone Friend relies on in this part of his case is Gray and New Orgarita Porcupine. That's a case from 1952. It's another decision of the Privy Council. Interestingly, it doesn't cite Regal Hastings, although, of course, Regal Hastings had been reported in the All England reports by that point. And the relevant extract for present purposes is at 2791. And the relevant extract is in the middle of that page, right in the middle. There may be an element of truth in all this. It constitutes an irrelevant speculation. If a trustee's placed himself in a position which his interest conflicts with his duty and hasn't discharged himself from responsibility to account, neither here nor there to speculate whether, if he'd done his duty, he would not have been left in possession of the same amount of profit. It's often been said a trustee who's accountable is not the less accountable if he shows the transaction is impugned is both reasonable and fair, and the principle is the same. And we respectfully submit the principle is not the same. It's a different point, the question whether there is a causation test. So our primary position is that both Brickenden...
It would seem to be against you, wouldn't it, this passage?
It's against us in what he says, but we say with respect it doesn't follow from the principle is not the same. The fact that it doesn't help you to show that the transaction impugned is both reasonable and fair doesn't answer the question whether you can avoid liability by showing that you would have made the profit anyway.
But that's what the point he's making there, isn't it, or the Privy Council is making?
Yes, absolutely.
Yes, okay. So
I'm suggesting it doesn't follow with respect to what he is saying here.
Mr. Crowe is relying on this as showing that this was established by or at the time of this particular authority.
Yes,
and
exactly.
he's right about that.
Oh, yes, absolutely.
Sorry, I thought you were questioning whether that was so.
No. So I'm questioning whether the reasoning is persuasive.
I follow.
I mean, it's a clear as possible rejection of a but-for test.
Yes.
It doesn't necessarily ban other aspects of causation from any consideration of the identification of the profits for which the fiduciary is liable to account.
I agree. Yes. Now, as of course the court knows, there is the possibility, I'll just mention now, but I'll come to it, of using the equitable allowance as a form of ameliorating the result. But in short, just looking at the time, in short, we submit that the equitable allowance is an insufficient way of dealing with the problem because it doesn't actually deal with the problem in a conceptual way. First of all, the circumstances in which the equitable allowance is available really is up to the judge in the individual case, and we submit it's an insufficient tool. It would appear that awards are never made in a sum greater than 50%, unlike, for example, contributory negligence. It's also been held that the equitable allowance is only available in exceptional circumstances, to pick up the language of Lord Templeman in Guinness and Saunders, a case in which my learned friend appeared. Now,
do you accept that proposition that it should only be available in exceptional circumstances?
Well, if on my analysis, the analysis we're contending for, it's fair to say that if there's a but-for causation test, although we haven't in our written case said that the equitable allowance would necessarily go, I think it's fair to say that it would be hard to see a scope for the equitable allowance if there were also, or if as part of the test, there were a but-for causation test.
Well, certainly in a case where the but-for causation test wasn't satisfied.
Precisely.
You wouldn't be liable to account.
Exactly. And if it was, I mean, really both ways. It's although we haven't said the equitable allowance is necessarily inconsistent with the but-for causation test, it's fair to say that it would be unlikely that it would survive or be applied in many cases if there were a but-for causation test.
Well, why should that be? Suppose that it can be shown that some critical aspect of what was necessary to gain the business opportunity for the fiduciary was one which he only acquired while he was a fiduciary and which he then misused for his own personal benefit, so that the but-for test is not satisfied by the fiduciary. He can't show that he would have made the profit in any event, but nonetheless he made a super profit by the application of an enormous amount of personal time and skill and risked his own property in doing so. Why shouldn't an equitable allowance why should it necessarily have no role to play in a case where the but-for test doesn't kill off the claim?
I'm not saying it necessarily does. It's not necessarily or conceptually inconsistent, but
I'm talking about practicalities rather than concept.
Yes, quite a number of the cases where it's applied in cases where the result would have been different if the but-for causation test had been applied. I accept there can be cases, we can conceive of cases where the equitable allowance would still have a role to play. I'm not arguing that the equitable allowance should go.
But you're not making any assuming we weren't with you on the but-for approach, are you making any submissions about what we should be doing about equitable allowances, or is that not part of your argument?
It's not part of my argument today.
Thank you.
Okay. just to pick up my note on where we are. So I was going to say, I know we've touched on Warman and Dyer, but Professor Virgo is going to pick that point up, so I don't want to have two sets of submissions on Warman and Dyer. So if my Lord Briggs will allow, I'll pass over that baton to Professor Virgo. The other point I was going to make immediately was just to point out to the court, and I think I can do this pretty quickly, that of course the Court of Appeal, both in Murad and in this case, have indicated that this question, i.e. whether there should be a causation test, is something which should be looked at, again, at the highest level. And there is obviously a good deal of academic writing on the point as well. I know my learned friend says that the balance of the academic writing is in his favour. I'm not quite sure how you weigh up academic writing in that way. It's fair to say that there are proponents on both sides of this particular debate. I don't think
it wasn't what the Roman Emperor who issued an edict that you counted the number of authorities, academic writers of the day, on one side and the other, and decided a case on that basis. The Code of Theodosius, perhaps?
Yes. Well, maybe if I can take the Orwellian approach, that maybe some academics count more than others in any particular in any particular field. I'm not going to identify those who do and those who don't. No. Let me move to what we propose. I just obviously need to keep an eye on the time as well. Do I understand that the court is not going to take a short break in the morning? I should just continue.
No, please, just carry on.
So, first of all, we propose that there should be a causation test. And while there are different options of causation test, we say primarily that the correct test here should be a but-for causation test for two essential reasons. First of all, it's a simple test. What has to be established is that the breach of duty is one cause of the profit being made, in that but for the breach, it would not have been made. And secondly, this is the standard of causation that's most beneficial to the principal and stricter against the fiduciary than is the case in other areas at common law. And as to the burden of proof, at present the burden of proof is on the defendant fiduciary to establish a given head of profit is not sufficiently connected to the breach to form part of the account. And that point is picked up by Lord Justice Clark in his dissenting judgment in Murad at 1962. Although we've set out in writing that there are various ways in which the court could vary the burden of proof, whether that's for different burdens for no conflict cases or no profit cases, or dishonest breaches or honest breaches, there is, of course, the simpler approach of just keeping the burden of proof on the fiduciary in all cases. So far as a remoteness test is concerned, which does exist at the moment, the current test essentially, as I said earlier, includes an element of remoteness. Indeed, in this case, the court may have picked up there was something called the RBS transaction, which the judge held was insufficiently connected to the breach to form part of the profits, and we submit that should remain, but it's not a substitute for a causation test.
But you accept that the burden of proof should be on the fiduciary?
Yes. Let me say a word, I hope quickly, about comparison with other areas of the law.
But just how far does it go? That if the fiduciary can show, well, I would have earned some of the profit, but perhaps not all of the profit, do you then sort of slice up how much of the profit he would have earned? Is it
Yes.
that level of granularity, or
Yes.
so the fact that he might not have earned all the profit that he's actually earned doesn't automatically knock him out if he would have earned half the profit, and he gets to keep half. Is that
Yes.
right?
Yes, and again, without treading on Professor Virgo's toes, that's one way of understanding murad. What the fiduciary can say in murad is, true it is, I'm in breach of duty, but actually, what that gave me was the 2 years, so to speak, head start.
Can I just ask you about your first proposition? Because you're saying at stage 1 there is a causation test, and in your submission it should be the but-for test. But in answer to my Lord Legate, I think you'd already accepted that even within the present law there is a sort of causation test. So doesn't it become that your first proposition is there has to be a but-for causation test rather than some other causation test?
Yes, that's a clearer way of putting it. The answer I was giving to my Lord Legate, and we may have been at cross purposes, but what I was seeking to, I was hopefully agreeing with, was the proposition that there has to be always some form of linkage and causation.
Yeah.
What I'm submitting is that we should be overt about that and say that there should be a causation test and it should be but-for causation. I hope I didn't misunderstand my Lord Legate's question, but that's how I understood it, and that was the intention of my reply.
Thank you. No, you didn't. I was also making the point, though, that but-for causation is by no means a universal test even of loss. Or, yeah.
And I think I was accepting that because...
For example, in the business interruption cases, we held that it was a cause of the business interruption that every case of disease in the country was a cause, even though you could on no view say that one occurrence of disease, of COVID, without that, there wouldn't have been a lockdown.
Yeah, exactly.
So but-for is not the only, horse in town, as it were.
It isn't the only horse in town, and I've identified why I'm submitting that but-for causation is the appropriate horse for this particular town. But absolutely, I mean, we can look at cases like Galoo, we can go back to Cowsans and Cowsar sine qua non, and this is a point which arises much more generally, as my Lord is putting to me, yes.
But can I put to you a case I was pondering, which is that hypothetical case, Lord Wilson, that a case of wine is delivered to your clerk's room, and I come in surreptitiously and steal it. But because you're a very generous person, had I asked you to give me a couple of bottles of the wine, you would have done so. We wouldn't say there that that my theft was not the cause of my entire profit, just because I could have obtained 2 bottles illicitly.
Yeah.
And I was thinking that that is perhaps analogous to the fiduciary's profit.
It's a sort of liquid version of Lady Rose's salami slicing and dicing.
Yes, exactly. Well, I have food and wine to contend with. But the test would be, for the purposes, we need to distinguish between liability and remedy. The fiduciary would be liable, and I appreciate I'm treading on duty and account, but let me just use this language because I think it can be a helpful way sometimes to think about it. There is a breach of fiduciary duty in respect of the case, the whole case. Mm-hmm. The question as to what the account would be, in my submission, would be the fiduciary, if the fiduciary could show that if he had complied with his duty, assuming he had a duty to ask, he would have been given 3 bottles. I think I have to say that on my case, the scope of the account will be 9 bottles.
And the scope of the duty?
Well, the scope of the duty would be, in this example, would be a duty to say, I'd like some of the wine, will you please give me some? I mean,
yes.
We can start splitting hairs as to whether the duty
but I think
applies
the duty,
to all the bottles.
the duty on that basis would be the duty to account for 9 or 10 bottles,
yes.
whatever it is.
Sorry, I thought yes, exactly. Yeah.
But you might play around with dishonesty, presumably.
You might play around with the...
With dishonesty,
yes,
in relation to your but-for test, which might perhaps make some difference in Lord Leggett's example.
Precisely, and we did avert to this in our written case. I mean, there are. I appreciate what I'm doing, and I hope the court doesn't mind me doing it. Because I'm advocating for a change in the law, my focus is on but for. I appreciate that there are a number of moving parts here, of which burden of proof is one, for example. And that's why in our written case we've, I hope realistically, noted the possibility that if the court was going to go down this route at all, one way of doing it would be to say, well, we may have a different test in cases where the fiduciary is honest, but not as where the fiduciary is dishonest, or the burden of proof will be different, or the scope will be different. There are a number of moving parts here, and I appreciate it could be said, well, I'm not nailing my colours to a particular mast. I'm nailing my colours to the but-for causation mast, and certainly the causation mast. But I accept that there are other bits of the ship, if I continue the metaphor, which would need to be made consistent with whatever the court decided on but-for causation. And that's why in our written case we've identified possible distinctions between honesty and dishonesty, no conflict breaches, no profit breaches.
Just to make it clear, if it was a dishonest breach, you might say, well, the but-for test should not apply.
You might do
as
that.
a matter of policy.
You might do that as a matter of policy. It's not my primary submission. But
your primary submission is it should apply in the case of dishonesty.
In all cases.
Bribery, for example.
In all cases, yes.
In all cases.
That's my primary submission. But as I say, in writing, we have identified that the court may well want to distinguish between cases of honesty and dishonesty. And just to pick up one practical point, because I know the court will be focused on, well, how a first instance judge is going to apply this. Of course, in the majority, I would say even the vast majority of breach of fiduciary duty cases, the question whether the fiduciary has acted honestly or dishonestly is often going to be an issue before the court anyway. Not always, but often. So although if the court were to say there's a different case in honesty and dishonesty cases, in some cases it would require an additional factual finding by the first instance judge, not in all cases. Now, I was going to say a word.
By dishonestly in this context, do you mean knowingly in breach of duty?
Yes.
Okay.
Yes. And to be clear, one of the issues in this case, and again we've set this out in writing, and I probably won't have time to develop it too much orally. I'll say a word about it when I get to deterrent. There can be two sorts of ignorance in cases like this. One is, I know I'm a fiduciary, I honestly think I can do X, Y, and Z, but it turns out I can't. But I did it honestly. There are other cases where people don't even know they're a fiduciary in the first place, or that they owe fiduciary duties in the first place. And as we set out in writing, the growth of fiduciary duties in the commercial context, and the fact that fiduciary duties can arise in circumstances where, had the parties set out their commercial relationship a little bit differently, you may have got to the same commercial result, but you wouldn't have fiduciary duties. That can be the effect. Indeed, one of the issues in this case is whether my clients even appreciated that they were fiduciaries at all. So,
but I mean, the first defendant was a director of the company, the claimant company.
Yeah.
Yes, I mean, to suggest that the laws only recently developed to make a director responsible is bold.
I'm not making that submission, but, and I don't want to go into the interstices of the decision in this particular case. I'm making a general point, which was raised in this case, as to that certain people often do not realise they are fiduciaries. And indeed, when the court looks at some of the, I'll come to this point in the context of deterrent, when the court looks at certainly a lot of the academic discussion in the bundle on the deterrent question, one of the questions people raise about deterrent is, well, some of the people you're trying to, quote, deter don't even realise they're fiduciaries in the first place. That's the only point I'm making.
Well, that is anyone who's dealt with directors of small companies will have encountered that phenomenon repeatedly.
Yes, but even outside the director's context, people don't appreciate if you're in a JV, for example, you may owe fiduciary duties.
Or many kinds of agents.
or many kinds of agents. Exactly. And especially when you could set up your JV with a slightly different structure. I don't want to get into relational contracts, but you could set up your JV in a slightly different structure, which has quite different legal consequences. That's the point I'm making. So it's not only, in answer to my Lord Reed's question, it's not only that I appreciated I was a fiduciary, but I honestly thought I could do X, Y, Z. There is also the anterior question of I didn't even appreciate I was a fiduciary.
I mean, on the facts of this case, I'm sorry to bring you back to them, but did the judge find that your clients honestly believed that they could do the things they did while they were a director and employed by the claimants?
Well, there's certainly no finding of dishonesty.
Well, it's the negative you're relying on.
Yes.
Yeah, but what does that mean? I mean, in answer to my Lord Reed's question, you did say that dishonesty means knowingly in breach of duty. Well, were they not knowingly in breach of duty here?
They were not. They were not. There was no. I don't want to repeat myself, but there's no finding of dishonesty. Again,
but I don't want. I mean, maybe we're sort of slightly playing with words, which is, I think, perhaps why my Lord asked you the question. What do we mean by dishonesty here?
Dishonesty here, dishonesty, I would submit, is the standard test, ought to be the standard test of dishonesty which we apply everywhere else.
The Ivy and Genting.
Yes, exactly.
But when you said, I just want to try and pin this down. I mean, it may be for one of your juniors to answer this, but is there a finding of deliberate breach of duty here?
Well, can we come back to you on that?
Yes, all right, thank you.
Yeah. I do want, and I appreciate one of the issues I have in this case is that I'm arguing for a general change in the law, but equally we need to deal with the particular facts of this case. I'm trying to keep them distinct, but
isn't it? There may have been no finding of dishonesty because on the state of the law as it exists, that's not relevant to anything. But that's if you then make it key to what the test is going to be, then it becomes very relevant. But you can't say, oh, well, there's no finding of dishonesty, and so we fall on the right side of the line of this new test which we're asking you to set.
Absolutely, and I hope I can candidly say, as we set out at the end of our written case, we absolutely accept that depending on what the court finds, it may be that for certain results, the court can, so to speak, if the court's with me on the question of principle, the court can determine the question of principle and determine the outcome. There may be other instances, where the court will determine the question of principle but cannot necessarily determine the outcome because, to pick up my lady's point, it may be said against me, well, you shouldn't get off scot-free because there's no finding of this, when that wasn't relevant at first instance. Equally, one of the points sometimes made against me is, well, where is the explicit finding that you would have been in the same position even if you hadn't breached your duty? Now, on that, we say, well, it's a primary submission, it's obvious from the facts. But if we're wrong about that, again, that's a case where it would have to go back for determination of that point, because that question, like the example my lady gave me, was not a matter on which it was relevant at all for the judge at first instance to find on the current state of the law. I mean, I didn't appear then, but if one, with greatest respect to Mr. Justice Cockerell, if one had said to her, well, we want a load of findings just in case the Supreme Court changes the law in a way that we can't presently identify, most first instance judges have got a busy enough diary not to make, if I may say with great respect, that sort of finding. So the short answer to my lady's question is, there may be issues which are relevant to the determination of this particular appeal, which this court doesn't have the factual finding, and there may be points for me or against me. I'm not seeking to escape by reason of an absence of a finding in circumstances where that finding wasn't a relevant finding at the time. Now, I wanted to say a quick word about some comparisons with other areas of the law. This will be a bit of a, given the time, a bit of a tour d'horizon, but I anticipate we've actually set this out in some detail in our written case. First, as to other equitable jurisdictions, equitable causation, it has long been settled law that causation and remoteness tests apply to equitable compensation. sorry, did I say equitable causation? You did. Equitable compensation, forgive me. As regards causation, the test applied there is but for, i.e. the breach has to be one cause of the loss. Sometimes it is referred to as equitable causation in that context.
That's in the context where you're reimbursing a loss.
Precisely. Yes, exactly. And just to be very clear, the reason why I'm mentioning this is if it assists the court to know what the position is in other areas, I'm not saying this area is the same, and I'm certainly not resiling from the clear answer which I gave earlier, that I'm not seeking to reopen the question whether if you show whether the fact that you can show the beneficiary did not suffer a loss is at all relevant to the question of accounting profits. It's merely for comparative purposes.
And you say that already stems from Target and Redfern?
Yes, exactly. Yeah. That's clear in Target and Redfern. To give the court the references, it's 2366 in Target and Redfern's. It's AIB 1329 to 1330. 1329 to 1330. Okay. And most recently MBI at 1883, that's paragraphs 59 and 61, and also 1903. And given the time, I won't take the court to those passages. Dishonest assistance. In dishonest assistance, the Court of Appeal has confirmed in the Novaship case, the reference is 2000, that there is a causation test. There, it's fair to say, the particular causation test is dominant or substantial cause, to pick up my Lord Legate's point.
Is there a page reference for that, Torrie?
2000.
2000, thank you.
And so we do end up with this situation on the current state of the law, that an honest fiduciary who unwittingly breaches his duty is treated more strictly, more harshly, if I use that word, than a dishonest assistant of a deliberate and dishonest breach of fiduciary duty. That's the current state if you compare Novaship to this case. Moving away from equitable cases, in contract, of course, there's a test of causation for damages in contract, effective or dominant cause. There's a useful analysis of that in Novaship as well, at paragraph 108, also page 2000. I was going to make a point that it may be said that, contrary to what Malone Fenn says in writing, that contract is the polar opposite of fiduciary duties, because contract is read in tooth and claw, and fiduciary duties are a test of a duty of loyalty. I haven't got time to go into all the authorities now, but of course we do make the point in writing that it's fair to say that in contract there has been a move, whether it's the increased willingness to find duties of good faith in my Lord Legate's judgment in Yanseng Party Limited, or the relational contracts in Post Office. That goes back to my earlier point that it's not right to draw a too hard and fast line between these different areas. Now, that's a comparison very quickly with some other areas of law. As to other jurisdictions, I will leave that to Professor Virgo. Let me now turn to the other side's critique of our case. And they make, as we understand, 7 individual critiques of our argument, which I'll try to take in turn. Let me set them out for the court, and if it would help, I can put this on a separate piece of paper as well, and we'll provide that overnight if that's okay. Just to run through them. The first is that our proposed test provides evidential and practical difficulties to the court. The second is that the current test is essential as a deterrent, just pausing there, those two are obviously the points essentially put in Murad and the other cases. Third, the liability to account is an absolute and primary obligation rather than a remedy for breach, which brings us into the discussion we were having earlier with my Lord Burrows and my Lord Briggs. Fourth, a fiduciary should have to account for all unauthorised profit. Fifth, there's no real difference between no conflict and no profit cases. Sixth, it's unhelpful to consider whether there's been a breach of duty. And seventh and finally, the current test is clear, simple, predictable and fair. So let me take each of them in turn and say a word hopefully about each. The first is the evidential and practical difficulties point. And they say, first, in assessing whether a fiduciary was acting dishonestly, that involves obviously looking into the fiduciary's mind at the relevant time, or certainly applying the current test for dishonesty. And secondly, that the court would have to assess hypotheticals, i.e. whether the fiduciary would have made the profit absent the breach. Now, we submit that neither of these is a persuasive point. The question whether somebody acted honestly or dishonestly, or looking into their state of mind and making findings on hypotheticals, by which I mean what would have happened if the fiduciary had not breached his duties.
When you say if he'd not breached his duties, how far back do you go to start the divergence from the reality into the counterfactual?
Yes.
I mean, in this case, would you say if they hadn't started turning the family against Mr. Jaffe, but I don't think you regard that as a separate breach of duty, do you?
You turn the clock back. I mean, it's going to be fact sensitive, obviously. You would turn the clock back and to the first point where the fiduciary has done something which is an element of the fiduciary's wrongful action, if I'm going to avoid using the word breach. You turn the clock back and say, if we hadn't taken the steps which we took, which the judge held were the breach of duty coupled with the resignation, if we hadn't taken those steps, what would have happened? What would have happened? That's where you turn the clock back to. And of course, that's necessarily going to be part of when my learned friend Mr. Pringle deals with the question on the facts of this case. That's obviously going to be part of it, because it's part of the identification of, so to speak, what was the wrongfulness which the judge held. And what we submit is that these sorts of findings, i.e. whether people have acted honestly or not, or what would have happened in a counterfactual, are findings which the courts make on a regular basis in a wide range of cases. And we therefore submit respectfully that Lady Justice Arton in Murad, when she was identifying at paragraph 82, which is page 1940, when she was identifying the justifications for the current rule, we respectfully submit that she was right to place little emphasis on this particular point. Now, the second point the my learned friend takes against me is the deterrent point. This may need a little more time, because it's fair to say that the deterrent point is the point which is perhaps focused on most in the authorities and in the academic writings as the best support or the best reason for the strict rule and the inflexible rule which exists at the moment. Poor old Admiral Byng is often trotted out in this context, being shot on his own quarterdeck, pour encourager les autres. And allied to this, it's sometimes said, well, there's no harshness on the fiduciary because the fiduciary can always seek the prior consent of the principal or the court before acting in the way which the fiduciary wants to act. And we submit that a policy of deterrent is a justification for the current test, doesn't withstand scrutiny. And we submit that for three categories of reasons. The first category of reason is this. It's clear law that the law in this area is not intended to be punitive. I mean, that goes back to some very old authorities. Now, one could make the law punitive to provide that on top of the profits received by the fiduciary, they've got to pay some sort of levy on top, or to provide the equitable form of exemplary damages, i.e. the fiduciary would have to cough up even more than the fiduciary's actually taken, pour encourager les autres, but that's not what we do. There's no comparable regime to exemplary damages at common law. Giving up all the gains is considered to be enough of a deterrent. But we do submit that that leads back to the question, giving up all the gains from what? And we need to identify the gains, all of which should be given up, and that brings us back, we submit, to a causation test. Second, in the concept of deterrent, we do need my submission to be clear about what deterrence is and what we're trying to deter with the current test. Now, the answer is, well, we're trying to deter fiduciaries from breaching their duties. And of course, not only their fiduciary duties, but their non-fiduciary duties as well, to which the fiduciary duties have often been seen as a fence. You impose fiduciary duties in order to make sure they don't also breach their non-fiduciary duties. That certainly appears in some of the authorities. Now, I appreciate that this court has looked fairly recently at an account of profits in a different context. The lifestyle equities and armoured case, which my Lord Legate gave I think a judgment on, and my Lord Richards also sat on it. One of the points made in that judgment, it's not in the bundle. If it helps, we can provide copies if the court requires. But one of the points made in that judgment, the reference is paragraph 156, is that while an award of damages can make the infringer, that's an IP case, worse off than if no infringement had taken place, an account of profits doesn't have that effect because, to use the court's words, the effect is simply to put the infringer back in the same position financially as if no infringement had taken place. Now, if that's right, and we submit with respect that it is, that necessarily means, we submit, that the account of profits must be limited to those profits, and I'll use this language, caused by the breach, and not extend to those profits which the defendant fiduciary, in this case, would have made in any event, i.e. even if there hadn't been a breach. Because otherwise the fiduciary is being put in a worse position financially than if no breach had taken place. And indeed, Dr. Van, in her article at 3269, notes that Murad is a case where the profit stripping arguably leaves the fiduciary worse off than when he started and leaves the principals consequently better off than they could have hoped to be. Now, there are a few other points I should make in this context of deterrence, because it is one of the principal points made against me. First of all, because we're trying to deter fiduciaries from breaching their duties, liability is strict. And as I said earlier, we're not seeking to change or water that down.
I'm sorry to interrupt you. It just occurs to me, I mean, lifestyle equities I haven't read, I wasn't in the case, but damages for the infringement of intellectual property aren't normally limited by a but-for condition.
Well, there's
account of profits.
Account of profits.
Account of profits.
Yeah.
Yes, I'm talking about it. I was talking about account of profits.
Profits aren't. I'm thinking, I mean, the leading case is Lord Shaw and Fernan in a case about a patent being exploited in a territory which the owner of the patent would never have traded in. But the infringer has to account for the profits which he earned using the invention in an area where no profits would ever have been earned by the proprietor of the...
But that's focusing on whether the proprietor would have made the profits in any event. It's not focusing on the question whether but for the breach of duty. That's the point I'm making. And I accept that the question whether the proprietor could or could not have made the profits, I'm not seeking to reopen that.
No, it couldn't arise, could it?
So what are you saying? That then the infringer of the patent could say, well, if I hadn't used your patent, I would have used some other technology which would have been just as good, and so I would have sold as many widgets as I sold using your patent. That's not the exercise that they go through, is it?
The only point I was seeking to get really en passant from Ahmed was this, that the proposition underlying the account of profits in Ahmed was that unlike damages where the infringer can end up worse off, in account of profits you can't be worse off because you're only stripping from them the profits which they shouldn't have. The only point I'm seeking to get from that is that when you ask yourself what profits shouldn't they have, it brings you back to, in my submission, a causation question of which profits shouldn't they have. That's the only point I'm trying to get out of
That would seem to imply that maybe within an account of profits one shouldn't be applying a but-for test, because you're saying if you apply a but-for test it removes some of the deterrent element, because it might well be that the present approach to the courts is leaving a defendant a lot better off.
This is precisely the point I'm coming to. This is the main point against me on deterrent. This is the main point against me on deterrent, is to say, on my test,
yes,
if all you have to do is to pay out or pay back or pay over the monies which you wouldn't have got even if you had not acted in breach of duty, that is an insufficient deterrent. Absolutely, that is the main point against me on deterrent. That's why I'm spending a little bit of time on deterrent, because the point I just made is that because I accept deterrent is part of it, liability should still be strict.
Yeah.
But we submit, and I hope this is part of the answer to my Lord's question, people are not deterred, in my respectful submission, from breaching their duties by knowledge, and I'll come in a minute to what knowledge we can sensibly assume that people have in this context of the law, by knowledge of the intricacies of the law of fiduciary liability. People are deterred from breaching their duties and their fiduciary duties by knowledge and the fact that they may be held liable for breach of fiduciary duty. And in the case of fiduciaries who are fiduciaries by nature of their position, for example, solicitors, accountants, and the like, they have the ability, were they so minded, to breach their duties every day and probably make significant profits by so doing. But if they did so, they will be found liable for breach of duty. That would not only result in public ignominy, but probably in them being struck off as well. And if any stick is needed to make a solicitor or an accountant act in conformity with their duties, it's the fact that they will be held liable for breach of fiduciary duty and the consequences thereof, and not the prospect of an account of profits.
Well, that may be true of a solicitor or an accountant, but I can well see it not being true of others who may be tempted to make profits through misuse of their fiduciary position.
Well, absolutely, and that's why, let me just, if I may, let me just develop the point, because absolutely, that's why my next point is most fiduciaries are honest, especially those who have agreed to be fiduciaries. To put it this way, if Mr. Boardman had read Boardman and Phipps, if I can put it that way, he would have sought consent before acting as he did, if he'd read Boardman and Phipps.
Yes, he faced a slight problem that one of the trustees was not in a position to give consent, so he'd have had to go to the court. And
yes, he would certainly have taken legal advice on his position. Not because, but he would have done that, not because he would be worried about having to write a cheque if he was ordered to account for his profits, but because he was honest and he would have wanted to do things properly. And being found in breach of fiduciary duty is not just a reputational deterrent, It also has the significant legal consequence, we submit, that you have to give an account of profits at all, even where the principal has suffered no loss. And, of course, there are no concepts like mitigation or contributory negligence to ameliorate the position either. And under the current law, as we've said, it's often uncertain what the scope of the account of profits would be. It's also often uncertain whether an equitable allowance will be permitted, and if so, in what amount. And so, at the moment, in my submission, there is no, and would be no clear understanding of the remedy which would form a basis for a deterrent. And we do invite the court to consider the argument set out in this regard by Dr. Van. The reference is 1978, as to the amount of knowledge one can assume in cases absent the solicitor and accountant
So the reference?
1978.
I don't think
That's novelship, I think.
It's
Oh, sorry.
The Van article was about 3269, I think.
Oh, sorry, I've got the wrong reference here. I wonder whether that's the old page numbering which may have survived. Can I come back and give the court?
When you say knowledge, so then they'd be best off not going to get any legal advice then, because they maintain their pristine ignorance of the scope of the duties. But how do you assess their knowledge if they go to a solicitor and say, I'm a director of this company, I see this opportunity has come up, actually I'd rather fancy pursuing that myself. Is it okay for me to set up my own company and pursue that? The answer is, well, it isn't now that you've come to see the solicitor and I tell you, no, you can't do that.
I think with this, I think we're at cross purposes. I'm not using knowledge in this sense. I'm answering I'm directing my submissions at the point whether the current rule is justified because it actually deters people.
This is a practical question, is it? Does it deter them?
Exactly.
But, I mean, what my Lady Rose is referring to is a commonplace that solicitors and counsel are regularly asked to advise in such circumstances and will often say, well, if you do this and are found out, you'll be accountable for all the profits you make, so you may not think it's worth the candle.
And you'll have no entitlement to remuneration for your time and skill. You will be at effectively the court's mercy for that remuneration.
Yes, but under my test, if the person went to get legal advice, the solicitor would say, well, any amounts which you cannot show you would have made anyway, you will have to give over, and there may well not be an equitable allowance or anything else.
What troubles me about your submission, Lord Wilson, is that I'm not sure it quite gets to the real force of the deterrence. As I understand it, the deterrence is there to encourage single-minded loyalty. That is, someone who in the performance of his fiduciary duties is concerned only for the benefit of the beneficiaries and not at all for himself, apart from whatever remuneration he may have bargained for becoming a fiduciary. And the moment you let in the concept, well, actually, you can be concerned for yourself, providing at the end of the day you can show you would have made that anyway, it does strike me that the focus of the deterrence on encouraging single-minded, unselfish loyalty is put at very grave risk.
Well, also there's I mean, I deal with His Lordship's point, but it also occurs to me that where your argument goes is some people are honest, they don't require deterrence. Other people are going to have orders for profits made against them, so clearly with them the deterrence didn't work. So where the order is needed, the deterrence hasn't been effected, and where it's not needed, it wasn't necessary in the first place.
Well, there is, if I may say with respect, there is something in there. What we are saying is that for the vast majority of fiduciaries, they don't need the deterrence because they act honestly. They're solicitors, accountants, bankers, whatever. There will be a category of people who, even if we were to say if you're liable, you've got to pay a surcharge of 20%, they would still act in breach of fiduciary duty, and they'd try to spirit the money away so that it couldn't be found and put it in a jurisdiction where our orders don't easily run. At the moment, it is a relatively small, we would submit, group of people who are deterred or might be deterred by the financial consequences. It's people who know their fiduciaries, who know or suspect that what they are thinking of doing might be a breach of fiduciary duty, are therefore acting dishonestly or recklessly as to whether they are acting in breach of duty or not, and don't really care otherwise, and don't care if they're found liable, i.e. it's only the account of profits which will put them off. So we do submit that is a very small category of people. And this does come to the argument ultimately that Professor Smith points. And let me just give my lords the right reference from before. The reference from before for Van was 3268.
Yes, and Van's argument, I think, is it's not so much that she doesn't see a reason for changing the rule, but she sees the severity of the profits rule being the best approximation of loyal service. That seems to be the thrust of what she's saying.
Yes.
Yes. But I mean, your idea about there being a very small category, I wonder about that. I'm thinking back to when the law commissions looked at directors' duties about 20 years ago, and Part 10 of the then Companies Act imposed all sorts of criminal liability on directors, but there had, for good reasons or ill, been no prosecutions whatsoever. And when we consulted with with interested parties on this, that the message was, please keep these provisions. They may not result in criminal prosecutions, but it allows responsible solicitors advising directors that the consequences of their action will be severe. The same might be said in relation to a very stringent rule in relation to the common law, in the common law here, that it allows solicitors to advise fiduciaries of the consequences of their actions, which would be a deterrent.
Well, that's why, I mean, ultimately this part of the case ultimately is a matter of policy, and it's a question of weighing up the relevant policies.
Yes, but what I'm saying is that in that context there is a deterrence.
Yes.
Yes, and it would be an encouragement too, wouldn't it? If you say the position should be that you will be allowed to keep that profit which the trust, the beneficiaries would have allowed you to keep, the answer to that is, well, go and try that out, go and ask them, and see if that is what they would agree. So it would be an encouragement to do that which at the moment equity requires, that you get authorization for the profit.
Yes. There is no doubt that, I mean, that is one of the supports for the current rule, and also it said, well, you can go to court and ask the court. But of course, we do come back to the proposition that there are lots of people who don't know their fiduciaries, and people who don't know that what they're proposing to do would amount to a breach of fiduciary duty.
Well, that's the sort of Phipps and Boardman case.
That's the sort of Phipps and Boardman case. But it goes beyond Phipps and Boardman. It goes beyond Phipps and Boardman. I mean, this argument is developed in the academic material, in particular by Professor Smith, at 3246. And where Professor Smith summarises the position, I'm just going to give the summary, is that in order to deter what he regards as, and I respectfully submit, is a small category of people, you impose sanctions on a lot of people who either don't need to be deterred at all, or haven't done anything that we necessarily want to deter, or who can't be deterred, the out-and-out dishonest brigade, either because they don't know their fiduciaries, or because they're fundamentally dishonest and won't be deterred. There is also a possible fourth point here, and this is made by Professor Jones in his article at 3183, that there may also be a risk that people are deterred from taking positions as fiduciaries because they are concerned whether the law will treat them fairly even when they are acting honestly, or, once they are in such positions, from pursuing profit-making ventures which might also benefit the principal. That last economic argument is another argument made by Dr. Van, also at 3268. So,
I must say, it seems to me quite dangerous for lawyers to speculate in any of these directions about what is or isn't going to have empirically an effect on people. It's poor basis for a legal principle to make assumptions about psychology, I think. It ought to be rooted on the underlying principles that determine what constitutes a profit and when you ought to give it back, not on some speculation about what effect it's going to have. Otherwise, you might say, well, why not just, if we need to, we should add on a bit more, because that's what deterrence requires. It just shouldn't be, doesn't seem to me a proper way to design the principles.
Well, that's why I started with, I don't think I mentioned Weissenguy, but that's the case where it says we don't have, it's not meant to be penal, and we don't have a rule that we add on 20%. And the reason why I've taken a little bit of time on deterrent is because that is the principal argument in the authorities and in the academic material for justifying this rule. And it's trotted out, if I may say respectfully, it's trotted out as if it was almost self-evident that we have this rule, it is a deterrent, and it operates as a deterrent.
There's that general point, but then there's the more specific point that you focused on, which is that the worry that your approach makes it a win-win situation for any fiduciary, that they are never going to be out of pocket by breaching their duty.
Let's just divide that into 2 points. So far as the amount of money which the fiduciary would have to give to the principal, the fiduciary would have to give to the principal all the money which the fiduciary cannot show the fiduciary would have obtained anyway, i.e. even if they had not acted in breach of fiduciary duty. So the burden is on them. Any questions are going to be decided against their interests if there's a doubt. The anterior point, and the second but anterior point, is the fiduciary will be held liable for breach of fiduciary duty.
Yes, so if the fiduciary sees there's a chance of them making $140 million, you say they will be deterred from that by the shame of being dragged through the courts, even if at the end of the day they can keep their $140 million.
Well, it depends who the fiduciary is. I mean, if the fiduciary is a solicitor or an accountant, and at the end of the day they take $140 million, and the court says, well, you would have made some money anyway, but only 100, so you have to hand over 40 million, I mean, they're likely to be struck off. And even if they're not struck off, the finding of a breach of fiduciary duty against them has very serious reputational consequences. But let's say the court finds that actually $140 million you would have made anyway. Well, in which circumstances my argument with respect is they would have made it anyway, and therefore they shouldn't have to account for it, because in the counterfactual, if they'd acted properly, they would have made the money, and this is not meant to be a penal.
That's in a way the point. If they had acted properly, they'd have sought authority. And this is designed to deter people from making unauthorised profits, or putting it the other way, to encourage them to seek authority.
But what it means,
and the outcome would be the same.
Yes.
The outcome would be, if they sought authority, on your hypothesis, they'd be allowed to keep whatever percentage it is, and that would be fine. So this principle encourages them to do the right thing, which is to seek authority.
And if they don't seek authority in circumstances where
then they bear the consequences of not seeking the authority which the law requires them to seek.
And I can certainly envisage a case where if they didn't seek authority in circumstances where they could have, but deliberately didn't ask the question, that's going to make the fact pattern very difficult for them to discharge all sorts of questions in the judge's mind. But
why?
Well, because the question, for example, whether they acted honestly or not, if that is going to be part of the test, if you deliberately didn't seek authority in circumstances where you could have, one could see a judge saying you've acted dishonestly. But my primary answer to my Lord's question is this. My Lord's question posits cases where you can go and knock on the door of your beneficiary.
Yes.
In my respectful submission, there are many cases in which you can't, because you either don't know you're a fiduciary or you don't know that what you're about to do is a breach of fiduciary duty. In those circumstances, you can't knock on the door. It's not that you could knock on the door but you've decided not to.
The way in which you're seeking to persuade us to, as it were, change the law does not take account of that, as I understand it. I mean, this would be a rather different principle that you're putting forward, that in the case of the ignorant and honest fiduciary, they should not bear the consequences. But that's not your case, nor is it really this case.
My case is that there should be a causation test in all.
Well, that's right, and so we're testing that.
Exactly.
But if you're to put I think seeking to put forward now by a rather different and much narrower proposition.
No, with respect, I was seeking to answer, with respect to my Lord's question.
Well, I know, but my question is directed to those who do know, as well as those who don't. Those
who do know, there will be a question whether in a particular case they could or should have knocked on the beneficiary's door and asked. And the fact that they didn't may or may not enable the beneficiary to say you were acting dishonestly rather than honestly.
I see. Right. Well, I mean, that all gets very difficult, doesn't it? Because if the principle is that you can keep what you would have been permitted to keep, how are you acting dishonestly if you don't ask in advance?
I absolutely accept that. My primary case is that you should be able to keep what you can show as a fiduciary you would have made in any event. And the question here is whether that undermines the issue of deterrence, which it is said underlies much of the current rule, in such a way as to counteract the other arguments which we say are in favour of that causation test. And in my respectful submission, a test which enables a fiduciary to say, I made 140 million. If I'd acted in conformity with my duty, for example, let's take a very simple case where the fiduciary had a particular bit of information which they should have provided to the beneficiary. And it's obvious if they had provided it to the beneficiary would have said, that's fine, you go away, you can do it yourself. They would have made exactly the same amount of money. In those circumstances, we say that the appropriate test should be the fiduciary should have to account for those monies which they can show they would not have made if they had not acted in breach of fiduciary duty. And we submit that should be on a but-for causation test. And when the question of deterrent is properly analysed, we do submit that it is a weak argument, partly, if I may say, for the point put to me by my Lord Legate. It's a weak argument to justify the current rule. The current rule needs to stand or fall, so to speak, on its own merits. But deterrence isn't a sufficient justification for it.
Well, in my wine example, I don't think it's much of a reason to say that the reason why you should have to pay for the whole case of wine is we need to encourage people to ask permission before they take things.
Yeah.
The reason is that the whole of the profit has been made from taking my wine. And if you say, well, I would have given you 2 bottles anyway, I say neither here nor there. The fact is you didn't ask. So it's Lord Radcliffe's point, really, in the Canadian case.
Yeah. That essentially is the policy choice. Absolutely. You either go down that route or you go down a causation test. But the point I'm on at the moment is that adding deterrent into the mix of the argument doesn't actually assist. That's the main submission I'm making. Deterrent is an insufficient justification for the rule. It's either unnecessary, if one goes down the route my Lord Legate has just identified, or if it is necessary, it isn't sufficient. My Lords, I see the time. My next note was accounting as a primary or secondary obligation. We might need lunch to fortify it before
Can I just put one marker down? Can I just put one preprandial marker down to be dealt with after lunch by whoever chooses? You are, I think, more or less acknowledging that you're asking us to change the law, and in so doing to depart from at least 2 House of Lords cases and probably 1 Privy Council case, the Porcupine Mines case. Normally, a party seeking that, and we're here for sitting 7 to think about it, comes up with reasons about changes that have occurred since those decisions which make them no longer an appropriate expression of the common law. I hope at some stage you or one of your team will deal with that.
Yes.
Thank you. That's all I wanted to do by way of a marker.
Okay, I'll leave that hanging then. We'll come back to that.
Thank you, Lord Wilson. We'll adjourn then and resume at 2 o'clock.